Good afternoon. My name is Jim Ludwig, and I'm the Major Gifts Officer here at Vegas PBS. And I want to welcome you to our seminar today. Our topics today will be on guardianship, care providing, and the importance of powers of attorney. We have three experts with us today. We have Patrick Clifford from Clifford Senior Law. We have David Strauss, and we also have Shannon Evans. They are here to help us with all questions regarding these three topics. But before we start, we are very grateful to have a sponsor for all of our seminars this year, and that's Silver State Schools Credit Union. So please enjoy this brief message from Silver State Schools Credit Union.
I'm Scott Arkels, President and CEO at Silver State Schools Credit Union. For the past 70 years, we have been committed to strengthening our community and providing excellent member service and financial solutions for every stage of life. At Silver State Schools Credit Union, our valued members are at the heart of everything that we do. Our purpose statement drives us, prioritizing people over profit. That is why we strive to be a good neighbor by investing time, money, and effort into partnerships that support our community. We are a proud supporter of Vegas PBS. Together, we are paving the path for financial success in our Southern Nevada community.
Again, we cannot thank Silver State Schools Credit Union for their partnership with us on these projects. Now, before we get started, we need your help. We need you to participate in this seminar so that we can help you. And in order for you to do this, what we need for you to do is, if you look on the right-hand side of your screen, you're going to see what's called a chat box. And underneath that chat box, you'll see handouts, and then immediately under handouts, you will see chat. Where it says type message here, where it says type message here, this is where we need for you to put your questions in. Now, we're going to do a test right now just to make sure that everybody can do this. And Las Vegas and Southern Nevada is starting to slowly open up. So a lot of us have been cooped up for a long time, and I'm sure there's a particular restaurant that you have missed. It could be something as simple as fast food, or it could be a gourmet restaurant. So right now, what I'd like for you to do in that area is type in the restaurant that you want to go and dine with. And we'll wait till we get some responses. And then be sure to hit send. Okay, we got a dim sum. Let's see if we have some more. I just want to make sure that everybody can respond to us. Cracker Barrel, okay. So we got a couple that are coming in. Sushi. Ruth Chris, okay, high end, nice. Okay, so you get the idea. So if you have a question for a panelist, and even if it is not exactly a topic that they are speaking of, but you have a question, please type it in here, and then I will bring that up to our panelists. What I want to do right now, though, is give you an update on what's going on with Vegas PBS. And to do that, we have our Director of Development, Sal Carrera. And Sal's going to give you a brief update on what's going on with Vegas PBS. And then I will then introduce our panelists and get the show on the road. Welcome, Sal.
Thank you, Jim. Hello, everyone, and welcome to today's virtual event panel discussion on guardianship and care providing. I'm Sal Carrera, Development Director for Vegas PBS. And we're so grateful you're here with us today and incredibly appreciative of our expert presenters, Patrick Clifford, Shannon Evans, and David Strauss. As for Vegas PBS, we're recovering along with everyone through this pandemic, and our community has helped us endure and overcome. Some highlights of yesteryear, however, is that the station was named Nonprofit of the Year by Vegas Inc. magazine. Another, for the last 12 consecutive years, incredibly, Vegas PBS has ranked in the top 5 most watched PBS stations in the country. And recently, Vegas PBS received 6 2021 Emmy Award nominations for documentaries and educational programming, including Showgirls, the Las Vegas Icon, PBS Kids Writers Contest presented by Janice Allen, Ryan Ahern Live in Las Vegas, Vegas PBS STEAM Camp, and Vegas Strong Connecting during COVID-19. I want to express my gratitude to all of you for being part of all of that Las Vegas PBS has achieved so far. Beyond programming, we're a connector in the community, a safe place for the exchange of ideas, a vital educational resource, a platform for career training, a critical link in the emergency notification system, and so much more. It's through your support that all of this has been possible, and I personally thank all of you for believing in us and the importance of the work that we do. This unprecedented time in our history underscores our global citizenship and provides a singular opportunity to accelerate partnership across all platforms. Members like you are the force behind our team, and I believe that supporting our work truly does improve our lives. Tom Axtell, our previous GM, was a PBS visionary and has created a history of excellence that is nationally known. Tom recently received one of the top national PBS honors, the Dan Miller Award for station leadership. He's built the station from the ground up, and many of you have been part of that journey from the beginning. I want to thank our Plan Giving Council for the work on these important financial education programs, and we're proud to bring you these important financial education seminars, and today is number 9 in the series. I'm looking forward to learning along with you about guardianship and care providing. I want to thank our 210 plus members of our Silver Legacy Society, those who have agreed to leave Vegas PBS as a beneficiary in their state. These testimonials and transformational gifts are vital to the success of our mission. I want to again thank Patrick Clifford, Shannon Evans, and David Strauss for their participation today. For this seminar to be a success, however, we need your participation. So remember to send your questions via the chat box, like Jim said, to the right of your screen, and don't be shy. Thank you again, and enjoy today's program.
Jim, you are muted. Jim, could you unmute yourself, please?
There we go. How about now?
Better.
Okay, technology challenges. I can't wait for us to be in person. I mean, I really can't wait for us to be in person. You do not know how much I can't wait for us to be in person. Okay, so right now we're going to do 3 poll questions, and this is going to help Shannon, David, and Patrick better help you. So the first poll question, Summer, could we please put it up? Are you planning on taking care of your parent or parents when they cannot take care of themselves? And please put either yes or no. We'll give you a couple seconds to get some responses. Just to let you know, your Source magazine will be on the way. Here it is right here. This month on the cover, we have Rick Steves' Best of the Alps. Let's see if we got a response. Summer, how we doing? And our response is a third are planning on taking care of your parents when they cannot take care of themselves, and 2/3 are not. So that's a very interesting response there. Let's do our second question. Do you currently have a medical and financial power of attorney And more importantly, do you know where it is? And by that, could you get it within 24 hours? And let's see our responses. 86%. So almost 90% know where it is and they have one. And about 10%, little more than 10% do not currently have one. I have a feeling after today's seminar, we will be up to 100% on that. And last but not least, question number 3. Have you or do you know anyone who has had experience with guardianship court proceedings? That sounds like a lot of fun. Give it a couple seconds. A plug for an upcoming show that we have. It's called Us on Masterpiece. It will be in June. So 44% have had experience or know someone that had experience with guardianship court proceedings. Very, very interesting. I'm sure the panelists will definitely be able to help those and also provide some insight as well. All right, so now comes the real fun part. We have 3 excellent panelists with us. For me, in the upper left-hand corner is Shannon Evans of Evans and Associates. Hi, Shannon. Let's try David Strauss. David?
Hello, everybody.
Okay, David's here. Patrick?
I'm here as well.
So, Shannon, are we back?
I think so.
Good, all right, okay. Thank you all for bearing with us. Again, I cannot wait till we get out of this technology thing and we can get back to being normal people again and meeting together in person. All right, so we're gonna start with a very simple question, and this is for Shannon and David to kick us off. And it's, please tell us in layman's terms, what is guardianship and why do you want to avoid it? And Shannon, can you start?
Sure. So guardianship is a process by which the court either determines how your finances or your living conditions are going to be handled. And there's 2 kinds of guardianships. There's for minors and there's for adults. Mostly we're talking about adults like parents or grandparents or people that are injured, but it can be for children too. If someone inherits from a parent and they're under 18 and there's not a trust or anything set up, which David's going to talk about, there sometimes has to be a guardianship process by which the payment of those assets to the child is controlled over time. So that's one way. So there's also guardianship of person, where the person's going to live. Are they in a nursing home? Do they need assisted living? Who's going to take care of them? And then of their finances. So there's different kinds, and sometimes they're both. And you can appoint your guardian in your will, which David's going to talk about, or you can let the court appoint one. Sometimes that's okay. Sometimes it's not. Sometimes there has to be a professional guardian or a public guardian because there's no one available for the person to have to watch over them. So there's different kinds, and it depends on what you need. Guardianship in itself, which Patrick is going to talk about, it's not bad or good. It's just a process by which the court controls and makes sure that your finances are not going to be misused and you're not going to be living in a really terrible place. There's lots of ways to control what you want for yourself, and same for your parents if you're competent and you can make those decisions. There's a lot of choices and there's a lot of flexibility. Guardianship itself takes about, what do you think, guys? Takes about 2-3 months. And
At a minimum.
At a minimum, and it costs some money. It's not free, and you have to, this is something interesting, you have to notify all the relatives to the 2nd degree. Some people are private and they're not happy with all their relatives to the 2nd degree, and they don't want their father knowing about their life, or they don't want their omitted son who's got drug issues knowing about their condition. So there's a lot of privacy issues with guardianship that cannot really be avoided. So there's other ways to do it with trusts and power of attorneys that the other guys are going to talk about that are a lot cleaner, but it's definitely a process that's applicable for some people. It's not a bad thing.
Okay. And then, Patrick, there are some current reforms that are coming out in guardianship. Could you please elaborate a little on those for us?
Sure. Well, I want to bring this up because even though we want people to avoid guardianship if they can, we don't want them to be afraid of it. It's a very intimidating process, but if people are afraid of the process, then they won't get the help that they need, and many people do need it. And that would actually leave them more susceptible and vulnerable to people who might do them harm. Now, if your perception of guardianship is based solely on watching The Guardians or I Care a Lot, you're really not getting the complete and accurate picture. Now, we know there were serious problems with the system here in Nevada, as discussed in The Guardians, but there have been reforms to take care of that. As a result of the public attention and the good reporting, some of the bad actors went to prison, others ran for the hills, but reforms were made, including changes to the laws that provided for stricter laws regarding the activities of guardians, better court oversight, and really a more transparent process. And there have been procedural place guards that have been put in place. For example, here in Clark County, where there used to be one guardianship commissioner, there are now 2 guardianship judges. And as Shannon was talking about, there's notice requirements. If someone's trying to get guardianship over you, you have to get notice of everything that happens. You have to be served with all of the papers, and you have an opportunity to be heard. So you get to go to court and explain why you think you do or do not need guardianship. But there have also been substantive changes. Most of this happened in the legislature in 2017, including the passage of the Protected Persons Bill of Rights, 19 specific rights that people have when they're under guardianship, and that's hugely important. Some of it you think would be common sense, but having it written down and being able to tell a judge, for example, my client has a right to be treated with dignity and respect, and the guardian has this history of emotional and verbal abuse. That can be grounds for removing a guardian. It's very, very powerful.
Got it.
Can I tell a
David,
story?
go ahead,
Can I tell
Shannon.
a little story? So,
Of course.
why it's really important who you pick to be your guardian, especially finances and who you're going to live with and who's going to make sure where you live. This happened to a real story, and I never name names. But woman and man were married for, I don't know, 60 years. They met in Germany when he was stationed there during the war. And they'd been married a long time, no children. And on their power of attorneys, which David's going to talk about, they named each other, of course, and then he named his brother. Fine. Well, he became a little bit early stages of dementia. He still knew what was going on, but he was a little bit starting the stage of having to need some help. And his wife, who was perfectly fine, fell and broke her leg. So for a short time, she had to go to the hospital. And during that time, his brother swooped in and became the guardian. And when she got to the hospital, they were selling all their stuff on the driveway. And he took over their money and he took it. He didn't have a job. He was not a good choice for the backup person. So things can go awry. You didn't expect it. He never expected that his wife, would break her leg and be in the hospital for 2 weeks. And that became a big problem. One other thing in that story is he wasn't fully incompetent. And so at some point we terminated the guardianship, and he and his wife were able to take care of their business together, primarily through her, by having a doctor say he's not lacking mental competency altogether. He couldn't balance his checkbook perfectly, but together they were able to weather through it, and we terminated the guardianship. But it cost a lot of money and grief and stress and time, and it could have all been avoided if they had picked a better second choice.
And David, you have some things to add about the importance of power of attorney. Is that correct?
Yeah, I think, planning ahead is probably the most important thing that you want to do. And I know there was a new Netflix movie called I Care a Lot, and it was really insightful why it's important, as Shannon brought up, to plan and pick who you choose correctly and take your time with it. I think usually, I like clients to plan ahead. Most of my clients, I don't do many guardianships because we've been doing durable powers of attorney for health and property in addition to funded revocable living trusts, and we detail instructions in those documents. I just want to tell the viewers, in 2019, we passed a bunch of new statutes regarding durable powers of attorney for health and property, and specifically they deal with whether you stay in your own home or not if you become disabled. With the statute now requires, if you don't initial one of the boxes, they could require a guardianship if you're taken out of your home.
even if you've done proper planning. So the key is get everything updated, make sure you look ahead. The people you choose, it's very critical. Usually the judge will obviously look at the best interests for a child in a will, even though you pick someone, making sure it's the right choice. But planning ahead and thinking about who you choose, as Shannon said, is critical. And we've done this for a lot of years, Patrick, Shannon, and myself, and that's where we delve into the different options that you should investigate and the people that you choose. One is for cash and manages your assets, and then one, the guardian of the person, as Shannon said, puts Band-Aids on bumps and bruises and watches you and make sure they make the right healthcare decision. So proper planning is critical.
David,
And
why don't you talk about, real quick, talk about the new clause they added to both power of attorneys about choosing you want to stay in your home. You want to talk about that box? That's a big thing.
Yeah, there's two. Now, one of the keys is that, we generally mirror the statutes when we're doing our durable powers for health and property, but they say it has to be in substantial form. And, my clients generally want to stay in their own home as long as it's reasonably safe and financially and medically reasonable. So we've adjusted a little, but as Shannon brought up, these two new clauses are statements of desires concerning your living arrangements. And if you don't initial one of those boxes, you could still, if you're taken out of your home or your agent wants to do that, which is most practical, you may need to get court approval to do it. And so the first box that a lot of my clients suggest, because we detail living instructions, staying in your own home, having manicure, pedicure, massage, beluga caviar, Cristal, champagne, 5-star restaurants. And I just got done having a gentleman stay in his own home, and it was 6 figures a month. And I was his trustee at 24/7 care, turned every 2 hours, occupational, physical, speech therapy 6 times a week with an LPN, RN, and CNA 24/7 can run very expensive. And I'm not saying all the viewers need that type of coverage, but it's important that you initial the right box if you're going to be taken out of your home with your consent, and they'll generally talk to you about it without having to go to court. Is that your experience too, Shannon, on those two new clauses pretty much?
Yeah. Patrick, I'm sure you've had similar things happen.
Oh yeah, and what the boxes say, one is I will give my agent the authority to put me in a proper placement if that happens. And the other box says, well, I don't want to, but it does clearly say that if you don't give your agent this authority, then you may have to go through guardianship. Now, this is really important because one of these reforms that we've seen is that courts are really looking for less restrictive alternatives to guardianship. So if you have your powers of attorney in place, or if you have a trust to handle your property, then there's no need for a guardianship unless something goes drastically wrong.
I'll have a little story. I'm the storyteller. So I had a man, really nice, and he'd been married to his wife for maybe 25, 30 years. And the year after they got married, she got the starting stages of dementia and Alzheimer's. So right away at the beginning of their marriage, he took care of her. And he did a great job, and he was a good husband. He still is. Well, he got some health issues himself, and he went to appoint a backup guardian. And she didn't really have anybody. So I tried to go to Guardianship Court and get a backup guardian, and they yelled at me. They didn't yell at me. They chastised me and spanked me and said she had power of attorneys before she got Alzheimer's, and she picked a second person. Even if that person isn't appropriate anymore, that's who she picked. And I said, sorry, but those documents are important. They listen to them.
Yeah, and that's why it's important to keep it up to date. We've had situations where, some will come to us asking for planning about their husband with Alzheimer's, and we'll look at the powers of attorney, and the well spouse has a power of attorney naming the husband and no one else. So if anything were to happen to you, the only person you have here is your husband with Alzheimer's, you need an alternate.
Yeah, and it's important if you plan ahead, either you will have your plan or you'll have the government's plan. And so Cecil Foster used to say that a lot, the gentleman who used to be a nice planning attorney here. And it's true. So plan ahead, be sure you pick the right people. But as Patrick mentioned also, these new statutes are from 2019. So all viewers, even though these were really drastically changed in 2009, where we got statutory powers of attorney for property, viewers, you need to get out there, get with your existing estate planning attorneys and get those updated because it's critical regarding that guardianship. Now, some documents you can tie in to your trust. If you had some of those living instructions and you tie it to the power of attorney, I think you can do some reliance on your trust combining these and maybe get away from a guardianship. But in the abundance of caution for sure, you want to statutorily follow the new forms that just came out in 2019. So that's my opinion. I don't know Shannon or Patrick.
Let's talk about something really important, pets. Okay. People love their pets. All right. This really happened. I tell stories. This recently happened. A client of mine who was not old, she was in her late 50s, passed away suddenly, and she lived in a remote area and no one checked on her, and she had a puppy, and the puppy ended up dying because she was in her home alone, maybe passed away for a week or two. So people that have pets need to have some backup people to check on them every now and then, especially if you live alone, even if that woman was young. And if no one hears from you for a week, maybe they should have a key to your house or call and make sure you're okay, do a well check. And the other thing is, we've talked about this before, is some of the hospices like Nathan Allison have a pet care program where they'll take temporary care or permanent care of your pets. And so you don't have to worry about them not being cared for, and they won't send them to a kill shelter. Otherwise, if you don't plan, I had a man who had one of those bad guardians that went to jail, and they came in and took all his pets and sent him to a kill shelter. And when he got out, his pets were gone. So you need to plan ahead what you're going to do with your pets. And one other thing that we all know about, your trust, if you have a trust, can say, these people are going to take my pets. Otherwise, the trustee will find a good home together, if you have two or whatever. And they can apply for X dollars per month to care for the pets, to make sure that they have food and grooming and veterinary. So you can plan ahead so that that doesn't happen.
And
Right.
all right, the one thing,
Oh, sorry.
and then we've clarified this before though. You can't leave your estate to your pet, but you can leave provisions in your trust to take care of the pet at a certain degree. That is correct, right?
Well, we have a Nevada statute right on point that says a trust created for one or more animals alive is valid. They look to the amount of the trust, and someone can petition the remainder beneficiary and say there's too much set aside, and then the trustee has discretion. But no, a trust for pets is valid in Nevada, but the judge can reasonably look at the amount, like Helmsley gave so much, and my daughter just brought this up, she's in law school, about that case. And I think, it has to be reasonable. I believe you could have some standing.
See, that's the one that had left all the money for the dogs, the shoe lady. Tell that story.
No, you go.
Leona Helmsley lived in New York, and she was quite wealthy and quite eccentric. And my understanding is that she had quite a bit of money, and she left it in like millions in trust for her dogs. And she said it was the dogs, not to care for the dog's money. And so that was, the court said that's a little bit too much, millions of dollars for dogs, because even the most ritzy dogs don't need millions. But still, that was just a little warning. She went a little too far.
And then Patrick, we talked about this before. Even if you do that, and let's say Fluffy, who is your dog, then passes away and there's X number of dollars for it, that's actually an opportunity to possibly help out a local charity. Is that correct?
That's right. I mean, every trust has a purpose, and in this case, the purpose is taking care of the animals. And when that purpose, it has been fulfilled, once Fluffy's gone, what do you do with the rest of the money? Well, you have a residuary clause that says, I can leave it, that money should then go to the caretaker, or it should go to the animal shelter, or it should go to someone like Vegas PBS.
Yes. So I have another idea. Why don't you guys talk about, let's have a conversation about people on SSI or Medicaid and what happens with inheritances. That's a big thing. And people don't realize that people are on SSI or Medicaid. Let's handle that, guys.
I think it's pretty critical. I mean, all the trusts I've been drafting for the last 12, 13, 15 years roughly have springing special needs provisions in them, so that if you ever need to qualify for Medicaid or Medi-Cal or public assistance, that we have this kind of built into the trust. Number two, Nevada passed decanting, and you are now probably allowed, if depending on the terms of your trust, to appoint that property for a special needs person into a decanted subtrust that has special needs provisions. I don't think it's as clean. I think there could be some arguments, but if you have springing special needs provisions in your trust, like, you pack a jacket when you go out of town, you don't know if you need it or not, but it's there. Those are like springing special needs provisions, and they should be in most documents. You have to be careful with retirement plans and whether you use certain conduit or accumulation provisions with those, but I will tell you, planning ahead and having that kind of language in your trust or will, you can have it in test, it will also, is very important.
Okay, let's do a story, and Patrick can apply it to facts. Okay, someone leaves, I had this happen recently. Someone left their estate to her sister, and her sister was on SSI and Medicaid. and she didn't change it to special needs. Now, why we changed it to special needs is there are requirements of how much income you can have if you're going to maintain your benefits, and it's really hard to get SSI and Medicaid. Patrick's going to talk about that in a second. And if you inherit $10,000 even, it can ruin your aid, and so you don't get it anymore. Also, the government can try to take the aid back out of the trust for what they spent on that person. So also the person loses their inheritance. You can change a trust sometimes, like David talked about. But here's another thing. I had a client that left an annuity, a beneficiary, to someone on special needs. It's not so easy to change that. They wouldn't let me change it. So it's going to ruin her aid, and it's about $200,000. And once that's used up, she can reapply. But you know, that's a very hard choice. What do you think, Patrick?
Well, that's actually, you hit the nail on the head. The reason why you want a special needs trust is because people who do have special needs that are receiving these benefits will lose the benefits if they have too much money or too much income. And there are these trusts set up that say how this money can be spent so that they can do this. And I've recently done a similar situation with an inheritance, and people don't realize if you leave it to the person directly, well, it's better if you set up the trust. But in the context of guardianship, just last month, I did a special needs trust for a young man who unfortunately had been in an automobile accident, had some serious injuries, and has been under guardianship since. He did get a settlement from the accident, not enough. There weren't any real deep pockets involved, but he got a substantial sum that will last him a little bit. But he didn't want to lose his Social Security, his SSI, and more importantly, SSI comes with Medicaid. So he would not have been able to afford the medical bills otherwise without that Medicaid. So we were able to take that settlement from the personal injury, put it into a special needs trust so he could continue to receive his SSI and Medicaid. And there's a lot of people under guardianship who are in that type of situation who are incapacitated and do need those benefits. And if they should come into money, well, the Guardianship Court actually had to sign off and approve the special needs trust before we could put it in place.
But I think, Patrick, isn't one of the issues with that, though, with the D4A or Miller Trust, where you set it up for yourself, is there's payback once you die to Medicaid. And if it's a third-party special needs trust, there is no payback. And that is why planning ahead and doing springing special needs provisions is critical, because they can just have that not have to be paid back when the award passes away.
Right, and let me just clarify that. It's if the person never had the right to the money, for example, if it's just a parent setting this up, as opposed to, they have this money as a result of a settlement or an inheritance, then there's that payback provision. So if you're going to be leaving money to someone with special needs who's on one of these programs, don't give it them directly. Set up a third-party special needs trust, because there is that payback provision. In the case I was just talking about, probably never going to come into play. The money is going to be gone long before there's anything to pay back. But if it's a substantial amount of money, wouldn't you rather keep that in the family rather than paying it back to the government?
I have a different topic that people don't always think about in guardianship. We talked about minors. As a single working mom, I don't want my life insurance being controlled by my ex-husband, her dad. Nothing wrong with him, but we're not married, and I don't want him handling my life insurance. So if you leave money to a child, or you die without planning, more importantly, no planning at all, and the child's under 18, their legal guardian will be the parent. And so a lot of people are blended families now, and they don't want the ex-spouse to be controlling the money. They want the stepfather to be controlling the money, or the sister, or the grandma. So you can do a lot of planning that's excluding people that you don't want to control money. What do you think about that, guys?
Yeah, that's why planning ahead is critical. As Shannon brought up, minors can't own property. And if you do a basic trust or plan ahead and have the life insurance paid to a sub-trust or your trust for the benefit of the minor until they become a certain age, that's the best way. And also, an 18-year-old generally can go into court and just get that money. And wouldn't you want to stretch that out a little bit and let them get through school, or maybe college and a year or two of grad school, and then become a beneficiary? So planning ahead is critical, and making sure you have the right beneficiary designations on your life insurance annuities, not naming a minor, as Shannon said, is pretty critical for our analysis.
Here's a new topic that I think everyone has seen. All of us have seen this. There's a lot of adults now, it's called LAT, living apart together. There's long-term relationships. You don't have to get married anymore. It's okay. But this is what happens when one person owns a house and they're not married and they get hurt or go to assisted living or die, the other person gets kicked out and there's no way around it. So what you got to do if you're not married, power of attorneys are critical because that person has no authority to talk for your medical needs or anything, and you may have lived together for 15 years. Talk about that, guys. I'm sure you've had it happen.
I do these all the time. You need to plan ahead because if you name your significant other or you want the significant other to live in the home and you have not put in writing that they get to do that, they will be thrown out. And Patrick, I'm sure you've had the same experience.
Absolutely. And again, when you get to making decisions for that other person, it's crucial that you have a power of attorney or guardianship. People don't realize in the state of Nevada, the next of kin does not really have decision-making authority over someone else's medical decisions. If you technically, there's a narrow exception for essentially pulling the plug on someone who's dying, but you cannot make medical decisions for your next of kin without that guardianship, without that power of attorney, and you don't want to have to jump through those hoops.
Even less boyfriends and girlfriends. They have really no authority.
Yes.
And I think also when you get this crafted by your attorney, whoever drafts it, be very specific. Who pays the bills? Who pays electric utilities and stuff if you're leaving them a life estate in the property? You want to define those rights pretty critically and plan ahead. And Shannon, this was a perfect topic because I've drafted probably 3 sub-trusts in the last week for providing life estates or estate for years for non-family members, non-spouses, and it's important.
Let's go the opposite route. Let's say your parents are great, they've been married a long time, and I'll be sexist. Let's say the mom dies. And what does the dad do? He gets a girlfriend, right? And then what does he do? He lets her move in. How often does that happen? Then the opposite happens. They let that person take control. There's all kinds of dangerous areas. I'm just opening up the door.
No, you're opening it up right. And that's why I use a lot of remarriage restrictions in my documents saying if mom or dad remarries, they have to do a prenup to protect the half of the person who passed away for children. Depends if it's a first marriage, second marriage. These are issues you need to flesh out because, yeah, I get that call. Mom dies, dad marries new young greedy spouse, dad dies and children are completely disinherited. This could be your lifespan. It happens within this short period of time and their machinery will not work as well 20 to 40 years from now as it does the day they come in. So planning is critical. And Patrick, I'm sure you have stories too.
Oh, well, yeah, I always say I think I've seen it all, but tomorrow's another day. But one of the things I really love about this, and speaking for myself, and I'm sure for you too, I love crafting an estate plan or a trust or powers of attorney that are really tailored to my client's needs. And like you said, if you don't have a plan, the government has one, you're not going to like it as much, and it's definitely not going to fit as well for you. And we put in things like, of course, the trust becomes irrevocable when the first spouse passes, so that the money can't be given away to someone else. We have put in provisions about, it goes to the grandkids, but the grandkids have to be, in this particular case, it was one son who had a number of children out of wedlock with various women, and his parents did not want those children receiving their money. So we wrote it in that in order to inherit, you had to be born or adopted into wedlock. Now, some people may not think that's fair, but what you do with your money is your choice. And you can write these provisions any way you want. And again, if you don't, the government has a plan, you may not like it.
And Nevada's government has really good laws. We provide great asset protection techniques for loved ones. You can leave property in a trust to a child. They can be their own trustee for health, education, maintenance, support, and it's free of divorce, bankruptcy, lawsuits, and creditors, generally where spouses get 0, grandchildren get all. So we have great laws in Nevada and use these laws, and I know Shannon and Patrick and I use these laws all the time to assist our clients.
Let's talk a little bit about a guardianship proceeding that happens. Now they've been doing it more on Zoom. They don't make you go down there, but I'm assuming you're gonna have to go down there again. And Guardianship Court itself, as Patrick's seen many times, is not scary. The judges are really nice to the people and they talk in plain English, and it's not like criminal court. They're really nice and it's pleasant. But on the other hand, the people, if they're capable of going to court, are required to appear. And sometimes that's okay, but sometimes they don't like it. And sometimes they're mad and they don't want to have any anybody helping them. A lot of times when you have a younger person that maybe grew up with a disability, they're very pleasant and they're happy to have someone at the court talk to them every year. They may have Down syndrome and they greet the judge and it's all okay. But some people are really mad. Sometimes when parents get a little older and they have to have a guardianship and they have to show up, they don't understand and they're really angry that they feel like the things are being taken away. So the court process itself can be okay or it can be alarming depending on how the person is with the situation. Does that make sense? What do you think, Patrick?
Yeah, and first I want to comment on the fact that there is now this remote conferencing technology, and we have been allowed to go to court. And I think in certain respects that's here to stay. COVID has its disadvantages in the guardianship context. It's much harder to keep track of the people under guardianship, particularly if they're in a facility and you don't have access. But in terms of access to the courts, this has made things a lot easier and frankly a lot cheaper. If the lawyer doesn't have to get in the car, drive to court, pay for parking and sit around, if they're just paying for the time they're on Zoom or Blue Jeans, that's one thing. But yes, you're right. Actually, someone under guardianship or who is proposed to be under guardianship has to appear at the hearing unless it's determined that it's going to be harmful to them to do so. But I think you're going to see a lot more people under guardianship who, rather than being dragged down to court, are going to be able to appear, appear remotely, and it's going to make the process, I think, a lot easier.
Here's a little story. I had a man who's still around, and he's the longest running guardianship in Nevada Guardianship Court. And his parents left him money in trust because he had a little bit of a partying issue. And so he was just going to spend the money as a younger person when he inherited. So they had guardianship back then. I'm not sure why. And it just kept going. Well, over the years, you got to pay somebody to be the guardian. You got to pay for an accounting every year. And Wells Fargo was doing a fine job, but they cost money. And he didn't really, his sister-in-law was doing everything. She was feeding him and taking care of him. So we wanted to terminate the guardianship and have everything put in a trust for his benefit. And so we had the guardianship hearing at my office, and here this little guy was sitting in this chair, and the judge just talked to him, and she said his name and said, whatever his name was, Bob, how are you? Do you understand what's happening today? And he did it on the computer, and he was like 97, and it worked out fine. It was really quite all right.
I want to kind of shift gears, and this is a personal pet peeve of mine. And David, I think you have a little bit of insight into it. And talking about elder abuse and how people take advantage of our elders out there. Can you please elaborate a little on that?
Yeah, basically, Nevada is very cognizant of this now, as Patrick was bringing up. We passed a law several years ago that makes certain transfers to certain caretakers and to people that provide services and to people that materially participate in the design of your plan void unless they're signed off by an independent attorney. So in my office all the time, we sometimes need 2 lawyers. They changed that law, not just to be transfers on death, but also for gifts while you're alive. So those statutes are critical. In addition to those 2 statutes, that statute, there are civil and criminal penalties for age 60 and above or any vulnerable person civilly, and it's double damages and attorney's fees and costs if they prove that there was advantage taken of an older or vulnerable person. Secondly, there's criminal statutes for 60-year-old and above if they find this abuse. I mean, the first time can be a gross misdemeanor or a Class C felony. Second time, it's even worse. So yes, we have laws. They are in Nevada. They're critical. And this void statute, I don't know about you guys, but I have someone come in my office, probably another lawyer, to review clients' documents and trends and gifts a couple times a month, I would say. So really
60
important.
is not that old.
I know.
We're all going to be there pretty soon.
It's getting close, that's for sure.
When it comes to financial elder abuse, one of the sad things is it's usually a family member. And sometimes it's not big money. I mean, someone's thinking, well, grandma has lots of money. She's not going to use it all. She wouldn't mind if I used it to fix my car because I don't have the money that's available. So it is kind of widespread. If it's big enough, it's when it tends to get caught. But people need to know that there are places you can go. There is adult protective services, used to be elder protective services, but they've added it for vulnerable people who are disabled. So it's not just over 60 anymore. And you can call and you can report this suspected abuse and they will investigate. And as you said, there are civil penalties, there's criminal penalties. But people should know that they can always contact Adult Protective Services. If someone is in an assisted living or a nursing home, you can always call the ombudsman as well. There are people in place who are watching. It's just the problem is people don't know who to turn to.
Got it. The question I have then is, let's say there's multiple kids in the family, and one of the kids thinks that one of the other kids is taking advantage of mom or dad, and that particular child is the current guardian of mom or dad. How does that play out? And obviously that's never happened before, because David's laughing right now.
That's an explosion waiting to happen. And everybody's going to lawyer up, and it's going to cost so much money that by the end of things over with, there's not going to be nothing left. It's just, it can be a terrible waste of money, but that happens every day, every day.
And at least in the guardianship court, you have a judge who is going to reach a decision. You present your evidence and the judge makes a determination. Of course, everyone is the hero of their own story. We recently got 2 calls from a brother and a sister, one saying that, my brother's taking advantage of my dad, and another one saying my sister is trying to, trying to avoid the transfer of the house to me from my dad. It's like, I can't take either of you as clients. But getting the call from both sides, I'm the one who took care of dad. That's why he gave me the house. No, he's trying to steal the house from dad. I mean,
also
like
though, Patrick, you know this, also the court makes you do an annual accounting.
yes.
So if someone's stealing and there's some evidence, you can oppose the accounting. And sometimes the opposite happens. It's not very much money, and the person's got like $10,000 in the bank, and they make you do an accounting. And then sometimes the guardianship court will let you do a small estate and let you kind of waive the accounting, because that can be a little expensive, and sometimes nothing's happening. You just have to tell the court everything's okay.
And that's part of the oversight. Yes, you have to let the court know, and I believe the number is 10,000. If the estate's worth more than 10,000, you have to do that accounting. And if you don't do that accounting, or you make a material representation on that accounting, the court can fine the guardian $5,000. So that's a little bit of a stick there to kind of keep people in line.
Can you fire your guardian?
Not
You
during
cannot
custody.
fire your guardian. You can revoke your power of attorney and get a new agent, but only the court can terminate a guardian, or can terminate a guardianship and appoint a new guardian. But you can certainly go to the court and ask them to do that, but you don't have the power to do it on your own.
If someone's got someone guarding a person in a state, that means they lack capacity. It's very hard for them to have a voice. It's very hard once the guardian's been appointed, unless there's some kind of real abuse thing going on, and other people can confirm the abuse and kind of file some kind of petition for the protected person. It's kind of hard for them to have a voice, really.
And I've had cases where family members have said, dad's not doing his job as a guardian, and he should no longer be the guardian, and maybe I should be as well. I should be instead. I didn't plan on doing guardianship when I came to Nevada. I didn't want to put on a suit and go to court. That's why I decided to become an elder law attorney. But there's a need. I started doing it, and it's been very gratifying work. And that one in particular, I have to say, helping remove a unfit guardian so that someone could actually have a better life.
I want to talk to the audience here for a second. Just a reminder, if you have any questions, please put them in the chat box. Chat box is located to the right of your screen. It's where you put your favorite restaurant. We've covered a lot here today. We got about another 5 to 6 minutes. I just want to make sure that we are answering anything that you have.
I have an idea that David didn't touch on, but he did a little bit. So who is the guardian? You can name it you can name who has power of attorney, but you can name your guardian in your will. And that doesn't make sense because a will means you're dead. But you name your guardian in your will. You can name first choice, second choice, in case the first choice isn't around. And that's really good if you pick the guardian you think might be the best one instead of letting the people pick for you. Do you agree, guys?
Yeah, you can name a guardian in your will. You can name a guardian, or you nominate a guardian in your powers of attorney. But one of the things I think, one of the great reforms that came out, there is now a guardianship nomination form that you can get from the Secretary of State, where you can say, if anyone should file a guardianship over me, this is who I want my guardian to be. And the first thing the court does when a guardianship petition comes in, they check that database. So
Oh,
they'll
this is
know.
this is a big thing. Sorry. You want your daughter in California to be your guardian. Fine, you can have an out-of-state person be the guardian. But if you don't name one, you have to have an in-state person be a co-guardian, which costs money. So you can't have an out-of-state person unless you pick them, right?
Absolutely. No, that's, and I think one other thing, we did pass a new statute in Nevada because for anyone who's dealing with someone who's deceased with burial, cremation, et cetera, where most funeral homes were not honoring durable powers of attorney because they say they expire on your death. And that gave that agent the ability to do your burial, cremation, et cetera. Now we passed a law that said, as long as you did a valid power of attorney and named that agent with that kind of instruction, those documents must be honored. And not all the funeral homes are aware of this. And I had to walk through 2 of them that we did change the statute. I sent it out and then they honored it because they're always afraid of cremation. So they want to bury everyone, which is very expensive. And, you know, we want to follow your wishes. And, you know, sometimes when you mention burial or cremation in a will, you know, they don't always look at that because that will is really effective once it's gone through the court proceeding to make sure it's valid, et cetera. But just know that, and now you can mention that in your durable power of attorney for healthcare, and that will be respected, and you can walk them through the statute and make sure they follow it.
Otherwise, sometimes they make you get hold of a million relatives that live far away. Maybe you're not even close with your dad and he has to say, okay, and all kinds of things happen. You have to notify all these people to get permission. Yeah.
But
All right,
as
we're coming to the end right now, but I want to give each one of our panelists a chance for what I call a final thought. And we'll go ladies first. So Shannon, what is your final thought? Or knowing you, it'll be final thoughts.
This is an interesting thing. For me, I'm a little over prepared. I have all my power of attorneys for my family in my car. And this is why. Every time someone falls or gets hurt, it's on a Saturday or a Sunday. And I don't have it with me, and we have to go to the hospital, and so I have it in my car. And here's another thing. Power of attorneys usually mean you lack capacity. But if you bring your medical power of attorney in with you to the hospital, your dad or whoever, it bypasses all these forms, even if they're fine, and you can get seen a lot faster. So be prepared and have it, I'm being weird, but have it in your car in a little envelope. It's not going to hurt you.
I have a question for you, Shannon. Could you take photos of your power of attorney and have it on your phone? Or does it have to be?
I don't know, Dave. I think they might, but I like to have the actual piece of paper
Right.
in my hand, because how do they know it's real? It might.
If I could just jump in with 2 final thoughts, one following up on that. There's also, you can have your medical power of attorney and your advance directive. There's a lockbox for that too.
Right. Yep.
So the hospital can find that. One thing I want to mention as a final thought, like I said, we have all these wonderful, this Bill of Rights for people under guardianship, but those rights don't mean anything if there's no one enforcing them. You have a right to have an attorney when you are under guardianship. And not only do you have a right, the court will appoint an attorney. And it's usually from the Legal Aid Center of Southern Nevada, and they do a wonderful job. There is someone there to advocate for you. So you're not just going to be run through the system. Someone will have an attorney to advocate for your wishes to the extent that you can make them known. Otherwise, they're going to make sure that the process is being followed and that your rights are being protected. I've done this pro bono through the Legal Aid Center. It is what makes the system work, is having these attorneys in place.
We got one question that just came in, and I'm going to let the experts handle this one. It says 90-year-old mother in Las Vegas since 2014 with trust and will and durable power of attorney originally drafted in North Carolina. Will the documents be recognized here on her death?
As long as they were validly executed in the state of North Carolina, Nevada will recognize them as valid here.
One thing to be really, really aware of is just because the trust exists, it matters how things are titled. Before the person passes, you have time to check all their documents, all their accounts, and make sure there's a beneficiary, or there's a trust, or it's pay on death, and make sure nothing is in that person's name alone, and then you can avoid the problems.
Yeah, generally trusts move with you. They're contracts state to state under the full faith and credit of the Constitution and the Commerce Clause. However, I would have them looked at by a Nevada attorney because some states like California have such strenuous trust administration. And if they direct that you must use California law and you're a Nevada resident, without recitusing the trust here, which is more complicated, you may have a rigorous administration. So I would say get with an attorney, have them look at it locally here and make kind of a judgment call. And my final thought is, planning ahead is critical. I think estate planning is an act of love, not an act of death. And you're planning for yourself and your loved ones, and it's important to get your documents and consider the trustees and guardians that you choose. And it's a real important thing to do. So that's what I would say is my big picture in closing.
And make your parents do it.
And it's never too young to start.
No.
Yeah. I mean, every adult should have powers of attorney in place, because you never know. I've represented someone in guardianship, 33 years old, hit by a car. Never thought he'd be in that situation. And it's also a great way, if you have young adult children, to kind of even the playing field. You're not a helicopter parent, but they can watch after you. You can watch after them. You can name each other as agents under power of attorney.
I've kind of stayed out of this seminar, but I have a personal experience. My 90-year-old mom passed away 2 weeks ago, but she had everything in place, and all I had to do was follow all the rules, everything that was laid out. I have the medical power of attorney, a financial power of attorney. When the decisions came at the end to go to hospice, not go to hospice, it was my decision. I was following everything that my mom wanted, and everything else. So it's vital. And they talked to me when I was in my 30s about this, and I thought they were insane. Why are we talking about this now? I'm in my mid 30s. You guys aren't going anywhere, but it has been planned for close to 30 years, everything that they wanted. And all I had to do was just follow through on their wishes. Granted, I am an only child. So I call that a blessing and a curse, because I got to make all the decisions. But then again, I didn't have brothers and sisters saying, why are you doing this, and everything else that was associated with it.
And aren't you glad you didn't have to go to court to ask for permission to do that?
Yes, exactly. And that's why this seminar and others like it are near and dear to my heart, because they're providing education out there, and we all need this. And I can't thank David, Shannon, and Patrick enough for the valuable insight they're bringing to everybody on that.
Thank you.
This brings us to the close of our seminar. I want to remind everybody that we have another one coming up. We take the summer off, believe it or not. We give these guys a break. They are volunteering their time for us and everything. But Shannon and David will be back in June for Wills and Trusts 2. And we will also bring in our resident comedian character, Rob Bolick. So these three are going to have a show that you will not want to miss. We're probably going to be in this format, but we could potentially be in person, but we got to wait a little bit. So that's our goal for what we have going on. And I just can't thank David, Shannon, and Patrick enough for everything that they've done for us here. We hope you have enjoyed this. We hope you have learned something. Please send us your questions if you didn't get them answered. I will direct them to Shannon, David, and Patrick, and they will get back with you on an individual basis. They're willing to have a private consultation with you. And let's see. That's pretty much it for this seminar. You're going to have a evaluation. Summer won't let you leave. It's kind of like a gift shop. When you go on a tour somewhere, they don't let you leave until you go through the gift shop. So we need you to fill that out. And again, we can't thank Silver State Schools Credit Union for agreeing to partner with us on all of these. So again, I can't thank everybody, and have a great Thursday.
Bye-bye.
Thank you, everyone. Bye, guys. Take care.